Ignoring a debt collector's call doesn't make the debt disappear. It makes a lawsuit appear at your door instead. And here's what nobody tells you. You don't even have to show up to court to lose. Most people who get sued by debt collectors never respond. They assume the collector is bluffing. They figure they'll deal with it later. But later has a legal name, and it costs you everything. By the end of this video, you'll know exactly what happens when you go silent and why it's one of the most dangerous legal moves you can make. And the one thing you can do that flips the whole situation around. Picture this. You have an old credit card bill. Maybe it's from a rough patch 2 years ago. Maybe you genuinely forgot about it. Maybe the amount ballooned with fees until the number on the statement didn't even look like yours anymore. The calls start flooding in. Unknown number on the screen. You watch it ring and go to voicemail. You figure, if I leave it alone long enough, it dissolves. The debt collector is not frustrated. They're not confused. They're not sitting there hoping you'll pick up out of the goodness of your heart. They're building a case. That filing deadline matters more than any phone call ever did. Because here's what debt collectors know that you probably don't. Ignoring them doesn't pause the clock. It starts a completely different one. Debt collectors, especially the big ones, aren't random people calling from a call center. Many are companies that buy old debt in bulk for pennies on the dollar. Your $3,000 credit card bill. They might have paid $150 for it. So even if they collect half, they win big. And they have one instrument that guarantees collection, whether you cooperate or not. A lawsuit. Picture the lawsuit like a trapdoor built directly into the floor beneath your feet. You're walking along, ignoring the calls, feeling like you've slipped free. But the whole time, you're standing on it. The moment they file, it opens. Here's how it works. The debt collector files a complaint in court. Now you're a defendant. The court issues a summons, an official document that says, you've been sued. Here's the case number, respond by this deadline. That summons gets delivered to you. In person, by mail, sometimes taped directly to your front door. Picture a Tuesday afternoon. You walk in from work, there's an envelope sitting on the kitchen table. Your name on the front, a case number inside, a court date, and a deadline already counting down the moment it was printed. And now the clock is ticking. Loudly. You usually have somewhere between 20 and 30 days to respond, depending on your state. That's it. 20 to 30 days to put in writing to the court. I dispute this. That window is short, and most people miss it entirely. But most people don't respond because they didn't recognize the summons as real, or they panicked, or they convinced themselves the whole thing would still somehow dissolve on its own. It does not go away. This is where most people lose without realizing the game already started. Here's the plot twist, and sit with this one because it sounds too absurd to be true. If you don't respond to the lawsuit, the court can rule against you without ever hearing your side. You don't have to be lying. You don't have to owe the money. The debt doesn't even have to be valid. If you stay silent, the court treats that silence as agreement with everything the debt collector claimed. That's called a default judgment. Picture a courtroom scale, perfectly balanced. The debt collector stacks their paperwork on one side. You leave the other side completely empty. The scale tips. They win, not because they proved anything beyond doubt, because no one appeared on your side to push back. That's a default judgment. A legal victory handed over because one party simply didn't show. And it is exactly as bad as it sounds. A default judgment is a court order with your name on it. It states you owe the full amount, usually with interest and legal fees stacked on top. Once that court order exists, the debt collector gains access to weapons they were never allowed to use before. Wage garnishment. Picture your paycheck as water moving through a pipe. Right now, every drop flows straight to you. A default judgment lets them install a tap in that pipe before it ever reaches your hands. Up to 25% of your disposable income in most states. You clock in, you do your job. A slice of every check reroutes directly to the debt collector, legally, because a judge signed the order, even though you never stood in front of one and said a single word. Bank levies. That's when they go directly to your financial institution and pull money out of your account. Not a request, a legally enforceable order. You check your balance on a Thursday morning. The number is wrong. No phone call, no warning. The judgment already handed them the key. Completely legal, also completely preventable. Also, completely dependent on you doing nothing. This is the part where most people feel like the system is stacked against them. That frustration is valid. The idea that someone can sue you, you don't respond, and suddenly they can reach into your paycheck without you ever standing in front of a judge feels fundamentally broken. Their legal team has a word for people who don't respond to a summons. They call them easy. But here's what changes everything. The collector's case may look airtight until you ask them to actually show their work. Every single one of those consequences, the default judgment, the garnishment, the bank levy, requires you to do nothing. The moment you respond to the lawsuit, the entire dynamic shifts. You're no longer invisible. You're a defendant, and defendants have rights. When you respond, you force them to prove the debt is real and valid. And this is where it gets interesting. Debt collectors, especially ones who purchased old accounts, often can't prove very much. The original records, sometimes gone. The chain of ownership from bank to buyer, sometimes broken. The statute of limitations, the legal deadline on how long they can legally sue you, sometimes already expired before they ever filed. Picture their case as a paper CUP filled with water. It looks completely intact from the outside. Apply pressure. Request documentation, demand proof, challenge the timeline. It buckles. Not because you fabricated anything, because they were counting on you never squeezing. Their entire strategy is built on you treating that summons like junk mail and tossing it in a drawer. The summons says, paraphrased, respond within 20 days or we win automatically. Most people let it sit. That passivity is the plan. That's been the blueprint the entire time. You write that you dispute the debt. You file that response with the court, you pay a small filing fee, and suddenly they are required to construct an actual case before a judge against someone who showed up and refused to fold. Does that mean you'll definitely win? No, but it means you're in the game. And being in the game is infinitely better than losing by forfeit. Now let's return to where we started. Old credit card bill, calls you didn't answer, summons arrives on your doorstep. Here's what you do. First, read the summons completely. Which court, what deadline, what exact dollar amount are they claiming? Second, check when the debt was originally incurred against your state's statute of limitations. If it's expired, that's a legal defense. Third, respond in writing before the deadline. Dispute the debt, demand they prove it. Fourth, if you can, consult a consumer attorney. Many offer free consultations. Some work on contingency. If the collector broke the law, the Fair Debt Collection Practices Act may require them to cover your attorney's fees entirely. Because debt collectors operate under rules they are legally required to follow, they can't call you at certain hours. They can't threaten actions they're not legally permitted to take. They can't misrepresent what you owe. When they cross those lines, you can become the one filing suit. The party trying to collect a debt becomes the defendant sitting at the other table. So here's the short version. Ignoring calls is risky, but ignoring a summons is the real cliff edge. Do nothing, and the collector can win by default and use that judgment to garnish your wages or drain your bank account. Respond on time, and they are required to prove the debt is real, valid, and legally collectible. Silence hands them the power. A response takes a portion of it back. The entire system is engineered around the assumption that you feel powerless. It assumes you'll ignore the calls, ignore the summons, ignore the judgment until the window to fight any of it has sealed shut. But not anymore. The one question I want you to sit with: if ignoring a debt collector is this dangerous and responding is this powerful, why does nobody teach this in school? Drop your answer in the comments, and then watch what happens when debt collectors break the rules. Because that video is the other half of this conversation.